This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we are talking with Ilan Wurman about his new book, just out from Cambridge Press, entitled A Debt Against the Living, An Introduction to Originalism. Ilan Wurman is a non-resident fellow at the Stanford Constitutional Law Center, and he is an attorney in Washington, D.C. He served as Deputy General Counsel on Senator Rand Paul's presidential campaign and was Associate Counsel on Senator Tom Cotton's campaign for United States Senate. He has been published in the Stanford Law Review, the Texas Law Review, and a number of prominent national journals. Ilan, welcome to the program.
Thanks for having me.
So in reading your book, A Debt Against the Living, a basic question that comes to mind is, why originalism? And maybe a further question there is, where does originalism come from? I mean, did our great and early figures in jurisprudence, John Marshall, Joseph Story, did they think of themselves as originalists, or is this something we've invented on our own?
Right. So the first question, why originalism? As I hope the book makes clear, there's a pretty intimate connection between originalism and the founding and our founding principles. So to ask why originalism is almost like asking, why the founders? Why do we care about the founders and the way of life that they envisioned, the way of government, I should say, that they envisioned for us? And so insofar as we think the founding matters and the founding principles matters, then as we'll see, originalism matters a great deal, and it touches on everything politically today. So many people can invoke the founders on different sides of a political issue. But where did originalism come from? This is a fun question because I say at some point in the book, when was originalism ever not a thing, right? It seems intuitive. And in fact, all our founding fathers were originalists, and members of Congress and the judiciary were originalists in the antebellum era. David Curry has this magisterial study of congressional interpretation of the Constitution. It's called The Constitution in Congress. It's in 4 volumes. And he says, when you look at this history, basically everyone was an originalist. It's just how people did law. It's how you interpreted legal contracts. It's how you interpreted statutes. It's how you interpreted treaties. And they really didn't see much of a difference with constitutions. Now, what kind of originalism is it? Do you go to just original intent, original public meaning? So we can get into some nuances there. But then originalism in its modern incarnation arose in the 1970s and 80s as sort of a response to moving away from what jurists and members of Congress had always done in interpreting the Constitution. And this was a response to sort of legal realism and the Warren Court. And so originalism in its modern form, which is very similar to how it was used in the founding era and the antebellum era, came about around 1971 as maybe its intellectual birth, and then in the 1980s.
So specifically, you think about the story of the Warren and the Burger courts and the well-known judicial activism that's attributed to those courts. Originalism is a response to what specifically? How does Chief Justice Earl Warren understand his jurisprudence and what he's engaged in? And then we get sort of maybe the biggest reaction comes out of Robert Bork's pen. So what is that clash about? How does that help us understand sort of the birth of originalism?
Right. So the key debates, I guess, in the Warren Court, one of the key debates was, I guess it was crystallized in the abortion issue, but also when it came to rights of criminal defendants. So what does the Constitution do? What was it intended to do? What does it have to accomplish? It has to balance self-government against the need to protect rights. And so the Constitution does both. And the originalists in the 1970s and 80s thought that the Warren Court was not being faithful to that original balance, because the Warren Court was discovering rights in the Constitution that weren't there, that no one had ever thought were there. And when you look at the text, they don't seem to be there. And so the originalists in the 1980s saw this as and in the 70s, saw this as an assault on that first end of government, the right to self-government. And they thought, and I should back up and say, these are very hard things to balance, right? Because they're often in tension with each other. It's our right to self-government. It's often majorities, popular majorities that infringe on the rights of minorities. So the founders struck a careful balance that I think has been remarkably successful. And the originalists in the 70s and 80s thought that the Warren Court was not being faithful to that balance and favoring it more to the right side and against the right to self-government, and when it came to very controversial issues.
So thinking here about, if that's, so this original mode, this first incarnation of originalism, you note in the book, is all about original intent, trying to understand the intentions of the founders, of those present at the Constitutional Convention. I assume we would enlarge that, the state ratifying conventions, the Federalist Papers, the first Congress. But then that receives, as you note, a decisive challenge from a number of progressive legal theorists, and also, Justice Brennan has a speech where he criticizes this on a number of levels, a very influential speech. And so then the response is original public meaning. But help us sort of understand this evolution, this ongoing evolution of originalist thinking in response to challenges.
Sure. So we're now in the world of the modern originalist movement in the early 80s, and it was centered on what Ed Meese, Reagan's Attorney General, called a jurisprudence of original intentions. And so the aim here was to discern the intent of the founders. Now, by the way, this is not a crazy idea, and it wasn't a crazy idea in the sense of law comes from authority. You have to, law is only legitimate if it does, the right things, if it's a good law, but also if its source is a legitimate source. And so if you believe law only comes from an authoritative lawgiver, it's not a crazy approach to law to try to discern the intent of the lawgiver. And that's, in fact, what we do with statutes. In statutory interpretation, we often try to discern the intent of Congress. But what is the best way to discern that intent? Well, through the external signs that they used. That is the safest, most sure way to discern the intent of the lawmaker. And so that's, in fact, how originalists in the 1700s, 1800s, that's how jurists did law. It's how Blackstone recommended doing law. You look at the public meaning, the original public meaning of the words, and from those words and their objective meaning, you try to discern the intent of the lawgiver. Now, there might be some problems there. Maybe you discover intent that contradicts the meaning, and we can talk about what we do there. So it's not a crazy idea, but the way it was described in the 1980s made it sound as though what we cared about was what a particular framer or founding father thought about a particular issue, and that's what matters. And this came under attack in a series, two famous articles. One was H. Jefferson Powell's article in 1985, in which he said the founders didn't intend for their intentions to govern, and therefore originalism is self-defeating. But Powell, in that very same article, actually showed that the founders were originalist in the sense we now understand it, of looking to the original public meanings of the words in order to discern that intent. The other assault came from Paul Brest in a 1980 article, which I think actually coined the term originalism, in which he says it's impossible to know the intent of the founding fathers because they all had conflicting intents and different intents. And so based on this two-pronged assault, originalism refined to what it actually was all along in the 1700s, 1800s, and so on, which is this original public meaning that seeks to discern the intent of the lawgiver through the original public meaning of the laws.
Okay, so thinking about that the original public meaning, are we still open, I say we, are originalists still open to a charge from historians that, as historians are wont to do, that the past is gone. And we never can really know the meanings of words unless we get into, as best we can, the specific world that those actors are living in. And so the past, being another country, it really can't serve as a source of meaning for us. And here, maybe we can introduce, I think, the source of the title of your book, We the Living. We who are now inhabiting this world and dealing with laws, challenges, and the problems of self-government. And so this project of originalism really can't be maintained in light of just the limitation of historical meaning.
Right. So there's a movement in history departments also that adopt this sort of reasoning about the world, that we are inherently creatures of modern assumptions and presuppositions, and when we look at the past, we have to translate the past into present meaning. We just can't escape it, right? We're always going to see it through a particular lens. On the other hand, thousands and thousands of students study history every year and get graduate degrees in history every year and study events that occurred thousands of years ago or hundreds of years ago with the intent of understanding how those people understood themselves. And so if this criticism is true, then thousands of students and thousands, tens of thousands of professional historians every year are wasting their professional careers. And the fact that tens of thousands of people don't think they're wasting their professional career, I think says something about this criticism, that yes, it's obviously true that we have to be wary of our presuppositions and our priors and our assumptions. But that doesn't mean that objective historical knowledge isn't possible. Now, it's hard and gets harder the farther back in time you go, but it's not impossible. And we have, especially today, a lot of sources and records that allows us, as best we can, to discern the way the founders understood themselves. It's hard. There's no doubt about that. But again, this challenge would apply to figuring out what Congress 30 years ago thought when it passed a statute. But we don't give up on this exercise of discerning the intent of Congress 50 years ago when they enacted the Civil Rights Act, right? I mean, if this is a legitimate criticism, it's to say that all historical work is futile, and I just never bought into that.
Yeah, thinking about it, a Stanford historian, Jonathan, and I might butcher his name, Janap, has leveled this criticism recently. And I suppose, and we could also come back with just a logical point, one that Leo Strauss famously made against historicism, that it itself is rendering a trans-historical judgment when it makes the claim that all knowledge is limited or time-bound or provincial, that it breaches its own argument.
Right. Either historicism is contradictory because it claims that there is no historical truth except historicism itself, or historicism is potentially true, but then you can't preclude the possibility that there are other historical truths. So it's a self-defeating position, and I think that's probably right.
Yeah, no, question. I mean, it seems also, and maybe these criticisms of originalism on this ground are really it's almost a new strategic ground that certain scholars seem to be reaching for to deal with, I think, the growth of originalist scholarship and we also say power on the federal courts, of thinking of a new way to deal with these objections as originalism itself has grown and taken on and shown itself the ability to withstand criticisms. But that also brings to mind, how has originalism changed? I mean, I think on Law and Liberty, our blog, we've had a number of, at times, intense disputes between advocates, we could say, roughly, of judicial restraint and judicial engagement. And yet both opponents understand themselves to be originalist. And one thinks of the school Randy Barnett has largely pioneered, where he would say he's an originalist, but the Constitution is really about the Ninth, as far as I can tell, the Ninth Amendment and the 14th Amendment, and understanding those to shape the Constitution in a powerful way of just being about really protecting natural rights.
Yeah. So before I get to that, if I may make one more point about the historical criticism.
Yeah.
I think you're right. It is this new movement to sort of trying to find a new ground to attack originalism. But it's also fascinating because what do the people who attack originalism on this ground, what do they propose replacing it with, right? They propose replacing the use of history and historical evidence with things like law and economics, or judges using their best judgment, so moral philosophy, making the Constitution the best it can be. But if lawyers aren't going to be good at doing history, what makes us so confident they're going to be good at doing economics or moral philosophy? It turns out they're all doing this thing called law. And sometimes law will entail economics if you're looking at, a cost-benefit analysis to determine, the standard of negligence. And, sometimes it might require some moral philosophy, and other times it requires doing history. And, these are all plausible tools. But I think if they attack history, then it raises the question why they exempt other fields, which are also contingent in many ways. From that criticism. But anyway, so thank you for the digression. To go back to judicial restraint versus engagement. So originalism has changed in the sense that a lot of the early originalists were strong proponents of the presumption of constitutionality, our right to self-government. Lino Graglia is an example of this, and that we should just defer to Congress more, allow them to exercise our right to self-government. And this has transitioned a bit as Randy Barnett really deserves most of the credit here for spearheading sort of this view of the Constitution that is more classically liberally oriented and requires the protection of natural rights, and therefore the courts should be vigorous in protecting these rights, but the rights of contracts and property rights and so on. But the libertarians, to their credit, are consistent, at least from the political perspective. All the rights of the Warren Court, for criminal defendants, for abortion, many of them do think those are protected too. They just think economic rights and property rights and contract rights are also protected. So I think this issue boils down to what I've said before, which is for a free Constitution to be successful, it has to do two things, and ours did. It has to balance our right to self-government with the need to protect liberty and natural rights. And I think the Constitution struck such a balance. And to the extent we should engage with that text, restrain Congress when it should be restrained, and not restrain Congress when it shouldn't be restrained, I'm all for engaging with the text. I'm not simply for letting Congress do whatever it wants because we prefer the right to self-government. The Constitution made a compromise among these. It balanced these. Now, many of the modern judicial engagement thinkers would go beyond that and seek to protect rights that I really don't think are there, that I'd rather see protected and could be protected as a matter of congressional enactment and so on, but I don't think are necessarily in the Constitution.
Well, is there a danger, though? I mean, and I just think about judicial engagement and restraint, and now in Jack Balkin and this sort of progressive originalism. If everyone can be an originalist, does it fall prey to some sort of latitudinarian type of a problem that it really comes to mean nothing, that it's co-opted and it's really lost that power that it had under Bork or Ed Meese, however much, it's been superseded, but there was a clear understanding, rule of law, written text, try to understand the meaning of the text. And now we get, Jack Balkin saying that, well, of course, something like the latest progressive invention of government is entirely constitutional. I mean, is that a problem?
Yeah, it is a problem in a one sense that just like any other tool can be used as a rationalization for particular preferred results, originalism can also be used as a rationalization for conservative results or for libertarian results or for progressive results, and which may be the case with Jack Balkin, but maybe not. The advantage, though, of something like what Elena Kagan said, which is we're all originalists now, is that at least we're all talking on the same playing field with the same sort of ground rules. We're playing the same game. And so if Jack Balkin's historical evidence is wrong, we can attack it on the historical evidence. Right? But if he weren't an originalist, if he says, well, I don't care about the original Constitution, I want, like Dworkin, to make the Constitution the best it can be, well, that's a whole other line of argument that poses different challenges. So in this way, we're all talking about the same things. And that's important. The agreement on higher order methods is also important, and especially because it gets us all talking about the founding again.
Yeah, I was, Balkan, and I'm sure you can describe it better than I can. It's this idea of a popular movement, of a popular insurgency, we might say, within the country, elevating what had heretofore not been considered constitutional or thought constitutional on the wall. You put it on the wall, and now we have to give it validation. We have to recognize it. And that movement that he's describing, I suppose, is so the most popular or the most significant ground of constitutionalism is self-government, and making those appeals public. We can now say there was a demand for Obamacare, and that had to be recognized. I mean, I understand his constitutionalism, originalism, to be moving in that direction. Am I wrong?
Right. So I think that's right, and it is certainly rooted in this notion that it has to be contemporaneously legitimate. It has to have contemporary support and contemporary social movements to back these changing sort of constitutional interpretations. Now, of course, the original Constitution also contemplated that, right? That was one of the great geniuses of the original Constitution, was that it protected only those rights considered most essential for the survival of a free government. And everything else, for the most part, it left for we the people to decide through the exercise of self-government, because the founders knew that over 200 years, over 300 years, we would evolve and progress on certain issues. Today, that's gay marriage and abortion. The founders obviously wouldn't necessarily have thought about those issues, but they knew as a general matter that we would evolve, and so they left things for the democratic process. The problem I have with the Balkan approach, which takes a lot from Bruce Ackerman, is who decides that there has been enough of a social movement to support changing constitutional meanings, but not enough of a social movement that an amendment would be able to get through, and so that we can amend the Constitution properly. So who gets to decide? Do the judges decide? And, a lot of these issues that are controversial today, if you look at public opinion polling, these are like 50-50 splits sometimes. And so it's a hard argument for me to understand, but I don't think it's implausible. A question, and this sort of gets into something I wanted to stress and maybe think about, is when we're thinking about, with the why or the meaning or the overall structure of the Constitution. We think about, so I think in the founders' minds, right? The Bill of Rights is added after the fact. We have Alexander Hamilton in Federalist 84 writing against the idea of a Bill of Rights. This is the Constitution itself is a Bill of Rights. It seems in their mind the most important parts of the Constitution, two structural ideas, federalism and the separation of powers. How does originalism really, can it speak with specificity to federalism and separation of powers? Or are those sort of these just ongoing competitive jostling ideas? We're going to have different ideas about what those mean, and they have to be settled in Congress. And it's only if there's something egregious that happens that maybe the Supreme Court would be brought in, but that, really that's got to be something, in the mode of self-government. And that's where originalism can't speak that well. So it's certainly harder for originalism to provide judicial answers to these questions, but that may not be inconsistent with originalism. I guess what I'm saying is originalism may provide a judicial role to deciding certain disputes between the branches, but the fact that the branches are having this interbranch conflict is itself part of the original design. On the other hand, I do think originalism sometimes could offer more answers in court for these separation of powers problems, but they've been decided the wrong way. And, non-delegation is an important issue that I know you're familiar with. Yeah. I don't see why the court couldn't enforce, at least on the boundaries, more of a non-delegation doctrine in order to maintain that separation of powers. Because delegation of powers, remember, is the Congress delegating its legislative power to agencies and to the administration. So although our doctrine calls it all executive power, right? When the agencies are rulemaking or bringing enforcement actions or adjudicating, it's all executive power. But under the Constitution, under the doctrine, but really, we know that they're doing more than that. They're actually exercising legislative power. So originalism might be able to tame that a bit, roll that back a bit, and try to properly distinguish between legislative, executive, judicial functions, and let the courts enforce it more. Now, it's not easy. This is a bit off topic, but the non-delegation doctrine is very hard to enforce. But I've actually got a paper. This is the Texas paper, where I argue that non-delegation is so powerful because it's so powerful that courts are afraid to use it. Because if you strike something down under the non-delegation doctrine, well, there goes the Clean Water Act, or there goes the Clean Air Act. Well, there might be a way to tame it, and I call it as applied non-delegation. And we don't have to get into it now, but we should think as conservatives, we should, as originalists, should think of creative ways to give courts manageable powers to enforce original limits in separation of powers cases.
Is there a clear textual hook for the non-delegation doctrine that you would have courts enforce?
Right. So it's disputed, but I think it's Article 1, Section 1 and Section 7, which, the way the vesting clauses work is Congress is tasked with the legislative power, and the executive can only execute the law. He can't make law. Now, this is disputed by some, like Tom Merrill and others, who say that the legislative power is non-exclusive, that you can, in fact, delegate it. I'm not convinced by their historical evidence, but that position is out there. But I think that would be the textual hook, the vesting clauses.
Okay. Yeah, no, it's interesting hearing you, talk about this. It seems to be one of the most interesting challenges from legal academia to the administrative state in the last few years has been Philip Hamburger's book on where he contests the very lawfulness of administrative law. But it's not a textual read, as you know. It's sort of a deep understanding of why English jurists opposed the Crown on these issues going back 400, 500 years to show that administrative law really is at odds with sort of background constitutional goals. I thought as I've thought more and more about his book, it's such an impressive and thoughtful way to challenge the administrative state. But it would be originalism of a kind, but certainly not the way we talk about it.
Right. But it is, in some respects, as you say, originalism of a kind, because the vesting clauses, aren't super clear on their face. If you were a Martian, visiting this planet and you saw the legislative power, the executive power, how would you know what these things meant? You would have to probably read Locke. You'd probably have to read some English constitutional history. So it can be baked into it, but it is a more complex argument. But that doesn't make it wrong as an originalist matter, but it's certainly more complex.
Thinking here, about the administrative state, this develops in the New Deal. And the New Deal, one of the last great constitutional crises that we've had. And I've often wondered, does that make originalism problematic? Because I think many originalists would contest, I think, from a theoretical point, a lot of the New Deal state that was created, and would challenge it on those grounds. Some would not. And I've wondered, is that a problem? I mean, this huge growth in the federal government and originalism basically has to ignore a huge part of what it believes in order to make sense of it.
It's certainly a problem from the originalist perspective, in the sense, if you believe that, as originally understood, a lot of the New Deal state really should have been reserved for states themselves to do, and not for the national government to do. On the other hand, you always have to accommodate political reality, and you have reliance interests that have grown around the New Deal state over the last 80 years, and even if it's originally unconstitutional, that might mean you have to keep 90% of it around, the next time a relevant Supreme Court case comes up. But there's no reason you can't chip away at on the boundaries, on the margins, the true excesses, and maybe slowly start rolling things back. If that position's right, I mean, you have someone like a Michael McConnell who thinks there's a national healthcare market and Congress can regulate commerce, and that includes a national healthcare market. So there are disagreements on that point, but you will always have to accommodate reality and political reality, and that just means we have a lot of work for us. But by the way, if there's no reason Congress can't get involved too. Congress has an independent duty to interpret the Constitution, and if those like Mike Lee and others think that a lot of the New Deal state is unconstitutional, then they should roll it back, even if the Supreme Court won't.
Yeah, no, it's interesting. I mean, this introduces an idea you mentioned in the book, and I, in certain respects, I disagreed with what you said, but I was glad you brought it up. And that's this idea of liquidating the meaning of the Constitution. The mention of this is in the famous Federalist paper, Federalist 37. Am I right, or Federalist 39? I think it's 30, I think it's 37. I think it's 37. Yeah, and just the idea of the Constitution will be difficult to interpret at times. Things are you write something down, but it's very hard to speak with specificity. It's a beautiful passage Madison has in the Federalist Papers on this, but the meaning becomes clear over time in various ways. And then he has, there's correspondence where he sort of details more and more what he's talking about there, and also famously from Madison. In thinking about liquidating the meaning was the question of, does the Constitution authorize the creation of a bank? He thought it was very clear the Constitution did not authorize a bank, and yet he changes his mind on that and comes to accept that creation of a bank constitutionally, because he says the meaning of the Constitution wasn't altered, but it was expounded, and it was expounded through legislation, through elections, and even through Supreme Court judgment. And so that in that way, the Constitution had been liquidated on the question. It seems to me something similar happened with regard to the New Deal, and that the meaning was expounded by various series of judgments and legislation and elections. What do you say?
Right. So the liquidation point is being worked out most right now by Will Bode. He has a paper on this, and I hope he publishes it soon. And the first thing to say is it requires the presence of an indeterminacy. So liquidation, right, the course of practice and decision-making on the part of the political branches or the judicial branches can't alter, as you said, the meaning if it's clear. But originalists, I think, properly understood, recognize, like John Marshall, that it's a constitution we're expounding. It's written in varying levels of generality, and sometimes it will permit a range of plausible meanings. Sometimes it won't be obvious if this act is unconstitutional or it's constitutional. Right? There's some movement among originalists, the original methods originalists, who think if you just work hard enough, use historical legal methods, you'll always come up with an answer. But I don't know if that's quite right. I mean, I still think sometimes the answer might be a range of plausible answers. And then what do you do then? So Madison argued that, well, if you have a series of adjudications and discussions and deliberations in the Congress, in the courts, among the presidents, among the states, and everyone settles on the question eventually, right, that was originally indeterminate, that might liquidate, it might fix that meaning, that position. So Madison originally opposed the bank, But I think he recognized that it wasn't entirely clear. I mean, his convictions were firm on it, but I think he recognized that, from a matter of text, it wasn't entirely clear whether a bank was unconstitutional or not. And so he refused to veto the bank when he was president on constitutional grounds. I think at one point he vetoed the bank, an initial version, on policy grounds, but he refused on constitutional grounds because he said the issue had been liquidated. It had been ascertained over a series of adjudications. Now, does that apply to the New Deal state? Well, maybe. So remember, it has to stem from an initial indeterminacy, in the sense that if the New Deal state is clearly contrary to the text and the original meaning of the Constitution, then liquidation can't be used to justify ignoring that text. But if there's legitimately a question on whether there's a federal power here, and you can look at Wickard v. Filburn, if there's genuinely an open question whether the federal government has the authority to prevent someone from growing wheat in his own home for his own consumption, then maybe that's become liquidated. But I think the constitutional answer was pretty clear all along. But let's suppose there was some indeterminacy, right? It also has to be settled through a series of adjudications. Now, maybe it has been in that case because Congress has continued to enforce the New Deal state. The states have acquiesced, and the courts have also acquiesced. So if these issues were originally indeterminate, then I think you're right. They would have been liquidated. But I think the cry you hear from many conservatives in Congress is that it violates the clear injunctions of the Constitution.
It's an interesting thing with the New Deal. You could also think about abortion. It seems to me we have not liquidated that. That is very much an ongoing debate.
That's right, and even
by these standards, yeah.
Right. That's right.
It's interesting. You began your answer, and I don't want to quibble over this. You said it requires an indeterminate text. My understanding is Madison and subsequent correspondents never thought it was indeterminate, the text, with regard to the bank question. It was him recognizing the expounding of the Constitution on the question of the bank, even though it contradicted his own personal opinion on what the Constitution required, which, it harkens back to, I think, this federalism, separation of powers as the two main ideas of our Constitution, which can never really be settled. Thinking also, when Publius addresses federalism, uses this idea of the people will decide the balance of power through the competency of the level of government. If the national government shows itself competent, over time the people will become more and more comfortable with giving it greater levels of power, which just goes back to my mind of there's something there of competition, of self-government, of meanings actually not capable of being fixed. And I've often wondered if that's just, that's actually a part of the Constitution, and originalism maybe doesn't, it doesn't invalidate originalism, but it suggests a very humble role for the judiciary.
I certainly think it humbles the judiciary. The concept of liquidation ought to humble the judiciary because, as Will Bode has said, it is at war with the concept of judicial supremacy, because liquidation requires a series of constitutional discussions and adjudications among all the branches and among the states. Yeah. And today, you can't really have liquidation at all, because as soon as the Supreme Court says something, you're done.
Yeah,
so
exactly.
That's to get back to the abortion issue. Even putting aside the public opinion split, there's nothing for Congress really to do anymore. There's nothing for the president to do. There's nothing for the states to do, because the Supreme Court spoke. It spoke once, and since then a couple other times, and it doesn't leave much else for the other branches to do. So as Will has said, liquidation is at war with judicial supremacy. On the Madison point, by the way, I think that's a very good point, but I would say that I think Madison could firmly believe his reading was right, but also recognize that reasonable minds might disagree, and therefore there is some indeterminacy or potential for indeterminacy that can be liquidated. Now, how reasonable the other side has to be and how much disagreement there has to be is an open question, like it is with Chevron deference. How much ambiguity triggers Chevron deference, right? Some people see it everywhere. Some people see it nowhere. So
yeah, I know it's contributing editor Law and Liberty Greg Weiner has termed liquidation of meaning a living constitutionalism on a very slow boil because it's fixed meanings would be fixed generationally. A question for you, and this is just sort of thinking of mine as as we all sort of watched the election unfold last year, then sort of the very shocking result, I think, at least to my mind, and thinking about the court. One of the things that kept coming up, and it does in every presidential election, but was interesting, I think, for a lot of our fellow conservatives in regards to the election of Trump. Many said they were going to vote for Trump just because of the Supreme Court. And it inevitably pops the question, did originalism unintentionally, I think, further enthrone the power of the court in our federal, national politics, as opposed to, where I think most of the action was supposed to be, as I read the Federalist Papers, and that's Congress. And actually, I've wondered, if we think about our politics, this battle between elites and everyone else, if really the real power and the future going forward for conservatism is actually going to be in this more populist front style of politics rather than sort of the elites on the judicial bench.
Yeah, that may be. The one thing I'll say, though, is remember, originalism has been around for a long time, both I'm now talking on a longer historical scale, from the 1700s, 1800s. It's, again, how they did treaties, statutes, contracts, constitutions, although, again, there was some debate over whether they always translated across these kinds of documents. But the movement from judicial review of the John Marshall type to judicial supremacy of the modern court, right, where the court doesn't just bind the parties, that it is the supreme dictator, so to speak, of what the law means and is. It is the supreme arbiter, I should say, and Congress and the executive can't really have anything to say in the matter. This, maybe Cooper v. Aaron is one of the early cases, and these were sort of legal realist times. This was a little pre-war in court, but those weren't originalist times. So insofar as originalism and the court played such a role, it's because the court has assumed for itself this power, that it now plays a very powerful role in our politics because of this assumption of power that was largely driven, I think, by progressive legal thinkers back in the 30s, 40s, and 50s. And so if President Trump was elected as a result, well, then, those on the left today, I guess, can thank their forefathers.
Yeah, no, I mean, that's a good point. I just thought more and more as the election unfolded, so much of it was about a court seat, and I thought this is just something. There's just something wrong here, and I thought about this power, because originalism, I think in the popular mind, does seem to suggest there are answers. There really are answers, and we have them, and we've been just kept off the court. And I've often thought, what if the same sort of energy were invested in, which is that there isn't energy in congressional elections, but it's sort of that prospect of self-government. I mean, the clearest proponent of this would be Wilmer Kendall, who writing in the 1960s. So he's seeing these early precedents roll out, and he's sort of like aghast at what's going on, and he stresses this part of this self-governing part that's been neglected. A question for you maybe here at the end. What do you see as the future of originalism going forward? I mean, both in the academy, but also more practically on the courts.
Yeah. So the first thing to say is what we raised earlier, we're all originalists now. Fleshing out that problem, so to speak. Are we really all originalists now, or are we just using it as a rationalization for particular results? So it's the challenge will be to do originalism in a way that seems earnest to readers. D.C. v. Heller is a good example. Whatever you think of the merits of the opinion, it's taken as an example of both sides doing originalism just to rationalize sort of their own results. And again, whether you think that's more true of one side or the other, it doesn't really matter. The challenge is going to be to show others, to show the citizenry and the public that originalism can be done conscientiously and diligently, and that it doesn't always lead to one's preferred political results. And it shouldn't, because again, the Constitution didn't fix all that many things. It knew that we would evolve and progress as a society, and so it left a lot of choices to the self-governing process, as you say.
Yeah, no, that's an excellent point there. A governing document, the Constitution is a governing document, not a policy document. I think that's an excellent point to end on. We've been talking with Ilan Wurman, attorney and lawyer, and the author of A Debt Against the Living, An Introduction to Originalism. Thank you so much for your time.
Thank you.
This is your host, Richard Greinch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.